live. This is Law Call.
And welcome to Law Call tonight. I'm attorney Chris Young with the law firm of Perry & Young. We're talking about estates, wills, and trusts, the whole basic probate process tonight. So it affects everyone. So if you've got questions, give us a call, 850-392-1544. If you don't feel like going on air live, you can always email us your questions at lawcall@wmbb.com. And we already have several email questions in the queue. We'll get those out and answer those questions throughout the night. But I'm joined by a good buddy of mine, John Maslick. And John, this is your expertise, buddy, estates, wills, and trust, and the whole probate process, right? And as I just said, it affects everyone. You know, whether you realize it or not.
Whether you like it or not.
Whether you like it or not, the good Lord's going to call everyone home at some point. Yeah. And you know, it's better to be prepared, and it's better to understand what you would like to have done when you pass away, number one, you know, and basically give a roadmap to the courts to make sure that your last wishes, or you know, maybe not your last wishes, but some of your last wishes are granted, you know, and whoever you want to leave stuff to, or however you want to set your will up and do your estate, you have a right to do that, because if you don't, Florida law is going to take over and take control of it. So tell us a little bit about your practice. You've been you've been on the show several times with us already, but you know, what are you seeing with this probate process? What's the big thing?
The big thing with probate is, like you just pointed out, whether you have a written will, and we call that being testate. That's just the phrase that we use in law.
Fancy word.
Yeah, because the opposite is, if you don't have a will, it's called the intestate, and that's when the state laws take over. Right. And that's got a set structure that you can't do anything about. You got to follow whatever the laws say. Whereas if you write a will or you create a trust, you get to designate who gets what, how much they get, what conditions you put on it, and whether or not, you know, really you get to have your wishes fulfilled.
John, does everybody need a will?
Yeah, I mean, the sad thing is everybody's going to pass away, and the glory is that we do get to go on to the pearly gates after that. But people left behind, you got to leave something for them. And even if you only have a few things, you do want to lay out how that goes, simply both for planning purposes, so you know it's going to go where you want to go, but also so your family knows what's going to happen and they're not fighting over it. That's really what we get down to, is keeping the family peace is what that's going to bring.
You know, I've always heard a will is basically a roadmap for the court to I guess, fulfill your wishes upon your death about what you want to have happen. But, you know, you said a fancy word, and a lot of people are like, what in the world does that mean? Intestate. Now, basically, you know, when you pass away without a will, Florida statute is going to kick in, and they're going to decide how to distribute your assets and who gets those assets.
Right. Yeah. And like I said, it's just a structure that's already set in the state laws, and it's going to break down, you know, in a way that may or may not be what you really want to have happen. And on the other side of the coins, may be detrimental to your family members. There may be some family members, there's a lot of moving parts in these things. We try to talk to folks about everything that's going on with all their family members and what they have. But there may be somebody that's getting government benefits. And if they get an inheritance, it's going to kick them off benefits. Now, that's great that you're leaving them something. But now when they burn through that inheritance, now they're left without anything, and they got to try and get back on government benefits. And usually we're talking about special needs, folks that are having handicaps, you know, need special care, that kind of stuff. That's just one example of how you can plan these things out to make them work for you and for your family.
Now, just because you do a will right now doesn't mean that you can't change it later. Right. I mean, you may, you know, get divorced, you may have more children, your circumstances may change, but you can always change your will, right?
Right, and you know, not to beat the drum, and it's good for law business, but we like to tell people to come in, we'd say every year if you got a lot of things going on, but at least every 5 years. Probably have your will checked with your lawyer that does that sort of work, for two reasons. One, things change in your life. Things change with your family, different people that you may have appointed to be what we call now a personal representative, but you may remember the term the testator, or not the testator, the testator is the person who managed the thing. In law school we learned about it, but it's a personal representative in Florida, which makes more sense. But that's the person that's going to administer and help run it through the courts.
And you can name that person in your will.
Name that person.
You don't want the court naming someone that you despised to manage your will, because they may just be the next best option or the closest kin, you know?
And that's what I was saying, is that you can pick who that is, and they may have passed away.
Right.
And so you need to figure out who that's going to be. So that's why you want to review it every few years, and the laws may change a little bit too. They're set pretty good, but little things may change.
Phone lines are open, 850-392-1544, or you can always email us at lawcall@wmbb.com. Guys, if we could put up the question from Ronnie, an email question that came in a little bit earlier before the show actually took off. I believe it's the next one. But we can do this one. I live in a rural community which has had several problems with aggressive dogs. A pit bull has bitten 2 people. Neither bite was serious enough for medical attention. One on her own front porch killed a neighbor's cat, attempted to bite a child, encircled and growled at a delivery man. Let's see here. The owners are well aware of the dog's aggressive tendencies. If someone is mauled, will their homeowner's insurance honor the claim? I'm thinking of an analogy that if you're operating a dynamite factory in your basement, your insurance won't cover you if your house blows up because you took unnecessary risks. That's from Fran. Fran, that's a great question, because in the state of Florida, we do not have the first bite free rule. And so a lot of states are like, well, my dog's never had aggressive behavior. I can't believe he bit somebody the first time, I get a free pass. And that's not the case, John. If you own an animal, and if you own a home, and if there's not an exclusion on your policy, and a lot of times insurance companies will ask you whether or not you have an animal, and if so, how big the animal is, and even what kind of breed the animal is. And then sometimes there are breeds that are excluded under coverage up under your homeowner's policy. But if there's no exclusion, typically speaking, Fran, the homeowner's policy would kick in the event that this animal attacks another human being. And John, we've seen this time and time again. It seems like we have something come up every couple of months with a major dog bite case. And the injuries sustained by those animals are very, very serious and can be very deadly at times. So, Fran, to answer your question once again, yes, absolutely, the homeowner's policy will kick in and pay if there are injuries sustained by that animal, and if there's no exclusion on that policy. But John, getting back to what we were talking about with estates and wills, guys, there's another question that we had come in, and it's from Ronnie, and it deals with a trust. And a lot of people are thinking like, well, do I need a trust now? And, how do I protect my assets? And, people use the word trust, and they use it very loosely because they really don't know what it means. So let's talk about this question from Ronnie. I'm considering putting my house in a trust. The house has no mortgage. If I put my house in a trust and I die, can I have a stipulation in the trust that the house will be sold and the proceeds will be split among people I choose? Ronnie.
That is it. Exactly what a trust could do. Yes.
Okay.
And
John, take us back to
right.
Just simplify this for you. Just walk us through a trust.
So basically, what you're going to do, and there are different types of trusts you can set up for different purposes, and I won't get into the details. We'll just leave it at that. There's lots of different things that you can do with it for different aspects. But the main one that we're looking at here is, how do you pass something down to your heirs, and how does it go the way you want it to go? Similar to a will, which just says, hey, this is where I want things to go. That's still, the will then still goes through the court process. You have to open a probate court case with the court downtown here or wherever county you're in, and then it proceeds through that process. And there's, again, statutory guidelines and timelines and things like that come with it, and cost, right? Lawyers and those kind of things. With a trust, you avoid that. You get to go ahead and say, I'm going to create this trust, and in America, we can create things that they're legal corporations, basically, is what a trust kind of serves like. It's not a corporation, but it serves that, because then you take that house and you retitle it in the name of the trust. Okay. Now, it's still your house. You still own it because you're the trustee,
right? Yes.
You're the one who owns the trust. It's kind of your best of both worlds. And then you set out the terms within that. I want it to go to these folks when I pass away and split the proceeds equally, or maybe not equally, however you want it. And then what you do is you have in that trust document, you appoint a subsequent trustee, which is the person who survives you, obviously, and they're going to administer it how you've said. And it doesn't go to court. It doesn't have those extra costs or anything like that. And it's very efficient and usually very clean and clear, because your wishes are written out right there.
Okay.
Yeah.
Well,
it's beautiful.
It's great question.
It is a great question.
We have our first call on the line, Gloria from Bay County. Go ahead with your question, please.
I would like to know, if you have CDs or you have an IRA account, will this, and you have designated a beneficiary, will this have to be probated?
If you have basically bank accounts or CDs, like you said, at the bank, They'll usually ask you when you open that account, who is your beneficiary? Now, this is different than if you co-own the account with someone, and there's lots of reasons we talk to people do or don't do that. But you should always designate a beneficiary. And funny thing, kicking back to our question before, you can actually make the beneficiary a trust, because if you have a bunch of money in there and you want it to be divided up different ways, you just say it goes to the trust, and then the trust is instructed to divide that out according to this plan. But yes, ma'am, as far as that goes, you can avoid the probate process in the courts by just specifying with your bank or whoever holds those accounts. It can be retirement accounts, whatever. Set that beneficiary to who you want it to go to. But keep track, check that every few years. Make sure it's correct and hasn't changed because someone hasn't, got on the wrong side of you or passed away themselves. You won't want to leave it vacant.
Gloria, thank you for your question.
Good
Phone
question.
lines are still open, 850-392-1544, or you can always email us at lawcall@wmbb.com. We're going to take our first break of the evening, and we'll be back in just a moment. And welcome back to Law Call. Tonight I'm having John Maslick with me, and we're talking about wills, trusts, and estates, and basically what we refer to as the whole probate process. We do have another caller on the line, Joey from Bay County, with a trust question. Joey, go ahead with your question, please, sir.
Good evening.
Good evening.
Hey there.
My question is, if someone dies and leaves you a trust and you're unaware of this, how would you be made aware of that, not knowing?
That's a good question.
Wow. Stump John on that
right?
one, Joey.
Well, and there's a little bit more to that, because I'm going to fill in a little couple of the blanks. Is what that ends up happening is someone probably leaves you something, some benefit out of that trust. It's the duty of the trustee to track down everybody who has something coming to them. Now, if you're talking about you've been made the trustee and you don't know about it, that shouldn't happen. If you're doing it through a law firm, they're going to make sure everybody who's involved knows that they're going to be playing that part, have that role, and make sure they're up to it. But sometimes it happens. People pull things off the internet and draft trusts and things like that. That may be a surprise to you as well as to some of the folks that may be expecting things. But what generally happens, and it really is important, is that there has to be a copy of these things, and this goes for wills as well. You want to make sure that you, in creating these documents, make sure somebody knows where the originals are and you preserve them.
Well,
and then it gets passed on. When you do pass away, they find it.
But it sounds like Joey's on the maybe on the receiving end, and he just doesn't know about it, or he may not know if there is a trust. And so, how do you go about doing that? So, like, we can file caveats with the court to let the court know. I guess not the court, but we'll file it with the court system to let people know when you have if you ever have to file a claim or file your estate, you got to notify us, right? Because we may have a pending claim. But in a situation like Joey's, how does he know whether there's a trust exists? And what happens if the trustee doesn't notify everybody or does not even file the trust and basically go through a probate process of executing on that trust, I should say.
So that's a big old question. We can, like I told you earlier during the break, I can talk a while on that one, but I'll try and be precise here. So there is a requirement that when there's a trust and then the original trustee's passed on and now it's going to be administered, it's going to be put into action as the words would be, you would file a notification with the court just saying, hey, there's this trust, this is a copy of it over here, a certificate of trust that exists, just letting everybody kind of know that it's out there. That doesn't always happen. It should, I think. But the downside is you would have to go search each county clerk's office to see if one's filed in all of Florida, and there's 67 of those. So there's not a really good process on that. It is incumbent upon the trustee to find all beneficiaries. So if you're a beneficiary, they got to try and track you down, and they got to do their due diligence, and they're a fiduciary, which means they are required to do so. And if they don't, and you find out later, or if they aren't doing something, they're doing something that's against the rules in the trust as it's laid out, you can bring them to court and enforce that against them. But again, it goes back to you have to have a copy of it to know what you're getting into.
But if Joey's family member or his person of interest, I should say, if he feels like he's entitled to receive something, and the person passed away in Bay County or maybe lived in Bay County their entire life, do you have to administer that trust in Bay County, or can you administer it in the other 66 counties besides Bay County?
It's, like I said, it's out of the court system. So it's not something that's going to be in front of a judge or anything like that unless there's a fight. And at that point, your jurisdiction rules would come into play. Who is the person bringing the claim, the beneficiary that maybe feels like something's not going right, or if it's the trustee defending it, there could potentially be a jurisdictional dispute, and then the court settles that. But mostly you're not going to be in court. That's the beauty of a trust. On a will, on the other hand,
you will be.
There will be, and you will be noticed, and you can still challenge jurisdiction differently because sometimes you pass away in one county but may have lived in another. Right. You can do that, but the trust has most benefits. The not knowing your beneficiary would be a detriment to
that. Yes. Right. Well, we have another caller on the line, Walter, with a tax question from Bay County. Go ahead with your question.
All right.
Thanks.
Yes, I would like to know, how do you go about preventing a loved one from having to pay capital gain taxes on property you leave behind?
Okay, that's a great question, Walter.
That's a good question.
It's basically dealing with basis. So go ahead.
Yeah.
So, John.
And I'll let you, if you want to, touch on basis. But my advice to most people is tax questions should go to tax professionals, not lawyers. But I will say this: there are different mechanisms you can create and put homes or anything that's going to be a capital gain item, any properties, into a trust. And so long as that trust owns it, the basis and the capital gain doesn't come into play until you sell it. So it can potentially continue to bring in revenue if it's a revenue producing item or something like that.
And Walter, by all means, when you retain an attorney, ask them the question about step up in basis when you inherit property from the person who has left it to you, because there's a lot of moving parts in our tax code right now, and some of the things that our federal jurisdiction, federal legislature is trying to impose. And one of those is the ever-changing death tax, which goes up and down. And so, Walter, it's a great question, but it deals with a basis question, and the magic word is kind of like a step up in basis. And you want to consult with an attorney who has a tax background that can give you that advice. But you can achieve what you're talking about if you go through the right channels and go through the right hoops and get it done.
And I will say this, in inheritance, the beauty of passing something down either through a will or a trust is that basis, as you're mentioning, the basis is what did you originally pay for it? You as the owner, the person who's going to pass it on. If you paid $100,000 for a piece of property and then you pass away 20 years later and it's now worth $200,000, we're just using round numbers. Hopefully it's a lot more than that. the new value is then 200. And so when your heirs go to sell it, the value basis is at 200,000, and there would be no capital gain between that point. But tax professionals will much better do that for you and advise you. So,
Walter, thank you for that great question, sir. We have another caller on the line, David from Callaway, with an estate question. Go ahead with your question, David.
Hey, David.
Yeah.
Can you hear us, buddy? Go ahead with your question.
Yeah. You know, the house we're living in, my wife and I, is not paid for, and she's going to need my income, basically. But I have like 3 rental homes that are paid for. So if I were to pass away, she automatically gets the rental homes and everything and gets the income from the rentals, right?
Be careful when you say automatically, because I'm not sure if you have any other children or if you have a will or some type of direction. But John, you want to kind of give a 30,000-foot broad answer to that?
If this person you're speaking about is your spouse, there's some automatic things. We like to say, we won't say automatic, but there are some default things, maybe is a better way to put it. That's the legal way to say it, that are going to come into play. It's going to be more efficient if this person is also on any of the deeds already, or you do have it specified in the will that these things happen. You know, if they're not your spouse or they are going directly to different children or that sort of thing. So there are ways to do that. If you're doing it with or without a will, it becomes a little more complicated. Like we talked about, the state laws structure come into play, and it's certainly not automatic.
So David, you have exempt property and non-exempt property, or I should say non-exempt. Your homestead is exempt.
Homestead's a big one.
But then you have these investment properties. So I would strongly encourage you to reach out to an estate attorney tomorrow, since this is already on your mind, because it's never too early to address this.
Yeah, you need to talk about it.
To just be proactive about it, because David, there's a lot of individuals that are in your same situation who have the same question about, how do I leave what I want to leave to my wife to make sure that she can have the income that she needs to pay for the mortgage on a home that's our homestead, and not be subject to any claims or creditors or whatnot against our investment properties.
That's right.
So great question. Thank you, guys. We're going to take our last break of the evening. We'll be back in just a moment. And thank you for joining us tonight on Law Call. We've had some great calls, John. Thank you, everyone, for calling in, and really great questions, because, you know, sometimes people are hesitant to call in, or maybe hesitant to ask a question. But every question that was asked tonight, John, there's so many people that go through the same thought process in their mind about what will happen when I pass away, and how can I keep everything that I've worked so hard for and make sure that it goes to the person that I want it to go to. And thank goodness we've got great lawyers like you in town that can meet with individuals, give them a roadmap, and help them and basically hold their hand through a very difficult process. And it can be. But you know, one of the things that we really loosely touched on before we get into our shout outs was how you can avoid the probate process, not by doing trust, but if you do have certain financial accounts with named beneficiaries.
Yeah, there's several different ways to do these strategies, and the easiest, and maybe not always the best, but it's easy, is to put the names of your loved ones on your accounts with the institutions that holds it, whether it's a bank, it's a retirement account, whatever it may be. And one of the things that I would follow up with that is, a lot of times these financial things obviously are what we're dealing with. We try to come in and look at that and give you a holistic view on things, because I mentioned it a few times tonight about getting with a tax professional or another stockbrokers. We work with them hand in hand to try and really make it an overall good picture for you.
One caveat: if you're going to put someone's name on your financial account, understand that they are an owner of that financial account. And so before you pass away, just make sure that they can have access to that too. But if you're going to do that, make sure it's someone that you trust. John, we're going to jump into our shout outs. You've got some puppy dogs that you want to give a shout out to?
I got a shout out to my mom. That is not a puppy dog.
That's not a puppy dog.
But she is really nice, and we like her. So, but I do have some dogs. I left TV on for them at the house. We got Molly, Murphy, and Midnight, obviously a dog. Okay. We got my brother Keith, Michael, and Nicholas up there. We also got Rachel out in the west side of the viewing area, and Steve and Angel, who are probably already in bed.
I'm gonna give a shout out that's not to John's mom too, to make sure that he set me up on that, because he was saying I gotta say, you know, good night or shout out to all my puppies. Didn't know he was gonna lead into his mom, but anyways. Ashley, my wife's watching with our puppy dog in bed. I'm sure he's snoring though. My mom is watching. Trey Smith, Judy Smith, Miss Pam Myers, Paula Frederick, all of our buddies and friends over at the Grand Marlin are watching tonight. The Buck. You know, he's who knows what will wind up on Facebook tonight with him watching. He takes always the most flattering pictures, you know, stills. And we have Nick Hughes. Nick, thanks for watching.
Old Nick.
So, but anyways, John, thank you for coming on tonight. We've had some really great questions. And guys, it's there's a lot of questions that were asked tonight. I'll say it again, that a lot of people have the same thought process, and we have great attorneys like John in our area that will more than happy sit down with you, help you plan a process that's better for you, that's custom, and a will is custom. It's very custom, and you know, help you understand your rights and what you can do, even, you know, as you're, you know, preparing for where you want your assets to go when you pass away.
And really, it's tough to talk about these things.
Yes, it is.
And we try to sit down and help you do it as easy as possible with your family and make sure everybody's kind of knows what's coming. So
thank you for watching tonight. We'll be back same time, same place next week, and have a good evening and a safe week.
See y'all.